Hi everyone, welcome to Legal Connect. Welcome to this space, a space where we talk about the legal issues affecting Nigeria and Nigerians. The only space available where we can analyze, discuss, and look at the legal implication on some of the policies, some of the laws that are enacted and implemented in this country, Nigeria. As I always say at the beginning of every episode, look to join this space by hitting the subscribe button, like the program, or provide comments where you think that I'm just talking a lot of garbage. Put your comments there or provide a comment. I'm open for debate because we are all learning. However, I provide my honest opinion and explanation on the different legislations that is considered on this space. And on today's episode, I have been prompted by the happenings around the community, the society, to look at the implication, the duty, and the obligations on every stakeholders, including the citizens, in relation to the new norm that we are now experiencing, that is the federal government and the Central Bank of Nigeria compelling us to go digital with payment system. That is, we should use more of our plastic cards rather than carrying around hard cash. There has been reports and people have experienced failed transactions, personal data being obtained to empty people's bank account. People get fake alerts and all the different kinds of problem that is associated with this digital payment system. And in the course of my investigation and research, I was led to the legislations that was introduced in 2015 by the National Assembly, and that is the legislation, the Cyber Crimes Prohibition, Prevention, etc. Act 2015. This legislation or this act of the National Assembly actually provide responsibilities and duty as it applies to the banking system and also individual customers. So based on that, I'm going to look at this act, especially Section 19 of the Act. And Section 19 actually deals with what we are looking to discuss today. That is Section 19 of the Act imposes a duty on financial institutions to safeguard sensitive information of their customers. And the section prohibits them from giving a single employee access to sensitive information. Financial institutions are to provide effective counter-fraud measures to safeguard their sensitive information. So, I'm going to read the legislation and then we're going to look in depth into the provisions under Section 19. Section 19, exceptions to financial institution posting and authorized options. Section 19, subsection 1 states, from the commencement of this act, no financial institution shall give posting and authorizing access to any single employee. Section 19, subsection 2, any person or persons authorized to give access to computer to employees and gives more than one access to any person or persons is guilty of an offense, and is liable to payment of a fine of 1 million naira or 7 years imprisonment or both. Subsection 3. Financial institutions must, as a duty to their customers, put in place effective counter-fraud measures to safeguard their sensitive information. Where a security breach occurs, the proof of negligence lies on the customer to prove the financial institution in question could have done more to safeguard its information integrity. So that is the Section 19 provisions. So let's look at the implication of this Section 19. As already stated earlier on, Section 19 of this Act imposes a duty on financial institutions to safeguard sensitive information of their customers. The section also prohibits them from giving a single employee access to sensitive information. Financial institutions are to provide effective counter-fraud measures to safeguard their sensitive information. Where there is a case of negligence of duty, the Act places the burden of proof on the customer to establish that the financial institution in question should have done more to safeguard its information integrity. The Act makes it an offense for employees of financial institution from issuing false electronic or verbal message with intent to defraud. So, the Section 19, in my opinion, was reasonably drafted until the legislators decided to mess it up. Why did I say they messed it up? They messed it up in the sense that they've concluded that if there is a case of negligence, the burden of proof lies with the customer. Let's just think about that provision for about 5 seconds. The burden of proof that the banks or the financial institution was negligent or is negligent lies with the customer. I don't know if the legislators have lost touch with reality or they are just ignorant for them to decide that where there is a case of negligence by a financial institution, the customer should prove that the financial institution should have done more to protect their information. This provision is just like a David and Goliath's contest. The only problem is that the Almighty God is not there to assist David. The Goliath being the financial institutions with the, deep pocket and work connections that they have at their disposal against an unemployed youth who his parents or relation have just deposited money into his or her account and unfortunately lost that money. And the legislature deemed it fit to require this individual. So this young man will have to prove, not even on the balance of probability now, it is on the highest standard of proof, which is beyond reasonable doubt. Because if it was on the balance of probability, which is the lower standard, this Act act or this section 19 should have put it in a simple text that this proof will be on a balance of probability, which is just 51%, whereas the highest standard, which is beyond reasonable doubt, that the judge are sure, so they have to prove that the bank could have done more. But the problem that this young man will be facing is the fact that the digital footprint, the transactions history are not at his disposal. There is no obligation that the financial institution should assist this young man in order for him to be able to prove otherwise, that the financial institution could have done more to protect his account or information. So is the young man is between a rock and a hard place. I would have thought that the legislators would have empowered or get the Central Bank of Nigeria, who's supposed to be, with inverted comma, supposed to be the regulators of these financial institutions, either stripped them of this responsibility or mandate them to live up to expectation. They will be a regulatory body, given the fact that the objectives of this, the objective, if you read the objective of this legislation, the objective is that A, provide an effective and unified legal, regulatory, and institutional framework for the prohibition, prevention, detection, prosecution, and punishment of cybercrime in Nigeria. So, if the objective of this act, as already stated, is to provide an effective and unified legal, regulatory, and institutional framework for the prohibition, prevention, detection, prosecution, and punishment of cybercrime in Nigeria, why then is Section 9 being drafted differently, putting responsibility on the customers to prove that the financial institution could have done more to protect their details? And B of the objective is ensure the protection of critical national information infrastructure and promote cybersecurity and the protection of computer system and network, electronic communication, data and computer program, intellectual properties, and privacy rights. So, Section 19 makes it an obligation on the financial institution to protect or safeguard the sensitive information of their customers. And protecting sensitive information does not necessarily end with putting the security measures in place. It includes sensitization, information, and training of their customer to be able to identify threats to their sensitive information. There was a program I was watching recently where someone called a person and purported to be willing to transfer money into the person's account as a result of supporting a candidate at the just concluded election. And the person foolishly provided their personal details, their bank card details, including the security pin, to someone that they've never met it, they don't even know, for the person to pay money into the account. And it turns out the alternative was the case, whereby the individual cleared the money in the bank account of this person. So it makes me to understand that a lot of people does not actually know what are sensitive information, and this is a duty on the bank to safeguard those information, and the means of safeguarding includes sensitization, informing their customers of what not to do, such as providing their data information to an unknown person, or even if they are a known person, giving their relations, their relatives, their bank card to go and withdraw money, or telling them their passwords and all the likes, because you never know who the third party that will get the information, what they will do with the information. So safeguarding your information is paramount. Are the banks actually doing enough in our current situation? They're actually doing enough to protect, to help the customers, to protect their accounts, to protect their money. And then when there is a problem with the account, it is expected that the customer should prove its case. But how will the customer prove his case if the customer does not have access to important information, important documents that will assist them to prove their case? I would have thought that the National Assembly would have provided a regulatory body, be it the central bank, even though they are not functioning according to their duties or according to their responsibilities. I would have thought that a regulatory body will be put in place whereby they receive complaints from the customers, and then they engage in the investigation of what the bank has done or has not done that would have caused this customer to suffer data breach. And that regulatory body will investigate by requesting information from the bank, and then requesting information from the customer and determine who is at fault. And then the burden is not on the customers to prove, rather the regulatory body investigates, and the decision is determined by the regulatory body, which is binding on all parties, unless the parties decide, the customer decide to opt out, because then the customer will have to look for money to pursue the case itself. In my opinion, having a regulatory body to deal with complaints, customers complain, is far, far more better than having the customer to prove that the bank was or is negligent. So, Section 19, I think it is my opinion that Section 19 should be amended to take away that responsibility on the customers to prove. Because I've been a victim of this process whereby I was double charged twice for a transaction, and the bank could not help. The bank did not even help. They directed me. I went into the branch. They directed me to call their customer service online, which I did. The customer service did not do anything, and so lucky I was able to get the money returned, the money that was debited from the account returned. And the saddest part is that the bank failed to return charges that I incurred as a result of that transaction. As you all are aware, anytime there is any transaction within the account, you are charged fees for those transactions. I think at some point in the future, I'm going to look at these charges, what the government is doing with these charges. Because the amount of money that the government or the banks are generating from these charges every day is ridiculous. You get paid your salary into your account and you get charged for that. You've already paid tax before you were paid. And then you get taxed for the money coming into your bank. And then each time you make a transaction, no matter how small the transaction is, you get charged again. So that is outrageous that the government is basically just charging everything. We are paying double. We are paying even more than double charges for a single money that we've received. So I'm hoping to look at this aspect of the banking system in the near future. But on today's episode, we are looking at the duty and responsibility of the bank, the customers, and the legislator asking the customers to prove its case is surprising, given the fact that the contest between a customer, an average customer I'm talking about now, because I know that there are bigger customers out there, but I'm talking about an average a customer that either unemployed or in a low paid job, and you want these customers ill-informed, not enlightened, to engage with a financial institution and prove that the financial institution has been negligent. I think that is a wrong approach, because at the end of the day, it is those less privileged customers that are going to suffer. They will continue to lose money without the bank taking responsibility or doing anything about it. So my proposal is that the National Assembly needs to appoint a functional regulatory body. I know that the CBN, Central Bank of Nigeria, is the regulatory body of the financial institution or banking system, but Central Bank of Nigeria is not functioning. It is dead in my own opinion, because I've not seen anything that they've done in aspect of regulatory regime. So it is high time that position, that responsibility is stripped from the CBN and given to an independent ombudsman, an independent regulatory ombudsman, who will investigate complaints from customers against their banks for all these atrocious transactions that we hear of: failed transaction, fake alert, and so on and so forth. So I believe that this Section 19 should be amended in order to take away that duty on customers to prove their case. That is what I wanted to talk about on today's episode. I hope you understood my explanation. I hope you understood the nature of Section 19 that we've got. The banks, to give them a duty that they must protect our sensitive information. But then when there is a breach, the legislature flips that around and requests the customer to prove its case. So I'm not in support of this Section 19. I think it is detrimental to the well-being of Nigerians who are caught up under this Section 19, which is very frequent in the society. Reports of different cyber issues. So I hope you've enjoyed today's episode. Please like the program, provide your comments. No matter what your comment is, leave it there, and we'll have an informed and reasonable debate. And also, I will encourage you to hit that subscribe button. As always, it is me, your anonymous lawyer, signing out and saying enjoy your week and weeks ahead. Take care now. Bye-bye.